Minister Lametti, a significant impetus for your government's Bill S4 is to better manage criminal court delays, which continue to be a major problem in Canada. And for 6.5 years, Minister, your government has been criticized for failing to fill judicial vacancies promptly, including by this Senate Legal Committee. The number of federal judicial vacancies across Canada during your administration generally fluctuates between about 40 to 60, and that's after this long in office. The most recent number on April 1st is an unacceptably high 58 judicial vacancies. Minister, you continue to create new judicial positions, as you did in this month's budget, but you just can't seem to fill them. I'm not sure if perhaps the trusty LiberaList database is down. Minister Lametti, filling judicial vacancies is solely in your government's power. You can certainly help to lessen the critical problem of criminal court delays in Canada, which can result in serious criminal charges like murder and sexual assault being dropped. Why is your government still so deficient at filling judicial vacancies 6.5 years after taking power and more than 3 years after you became Justice Minister?
Well, thank you for the question, Senator. I obviously disagree with the basis for your question. I think we've done a very good job filling judicial vacancies through two general elections. And the first one in particular, we weren't used to the fixed election dates. And the next time around, I think we will be clearly filling vacancies until the writ is dropped, which wasn't the case in 2019, which is the cause of the largest number of, I suppose, backlogs from the period from 2016 to now. I have been successful, as you have noted, in getting additional judicial vacancies, and we have put into place a rigorous process. And that rigorous process, when it comes to creating judicial and refilling the judicial appointment committees across Canada and making them representative, that takes time. They have two-year mandates. But we have appointed over 500 judges of very high quality. I do not use LiberaList. I've made that clear publicly a number of times, both in the House of Commons and outside of the House of Commons. So that presumption is false. It's a merit-based process, and I'm very proud of the judges that I have appointed, and I'm proud of the judges that our government has appointed.
Well, your Prime Minister's office has previously admitted using LiberaList from their point of view. But anyways, you've given me the same answer on the judicial vacancies prior to the 2021 election. You gave me that answer about the 2019 election. We've now since had another election that your government called, so that was obviously in your own power. But I want to move on to another thing. 5 years ago, this Senate Legal Committee produced an excellent, lengthy, and comprehensive report after an 18-month study into criminal court delays in Canada. And it contains so many helpful common sense measures to help combat criminal court delays. Our report was called Delaying Justice is Denying Justice, and it was prescient in many respects, and especially on technology. Minister, you didn't mention this key report in your opening remarks today, and so I hope you haven't forgotten about it. What my question is when you were drafting this bill, why didn't you employ many more of the measures, the very helpful measures that were recommended by our Senate Legal Committee in that report?
Thank you for reminding me of the report. Of course, it's an important report, and it is a resource that we have. This particular bill was the result of, in particular, provinces and territories telling us what they needed during the pandemic. So this particular bill represents a consensus of provisions that were suggested by the provinces in particular, very much supported by the judiciary, both on the Action Committee indirectly, as well as the other consultations that I've had with members of the judiciary in support of this bill. So this is meant to address telecommunications, COVID, making the system more efficient to address these delays.
Merci, Monsieur le Ministre.
It doesn't preclude further reform, Senator.
Thanks very much. Minister, your bill allows an accused to testify at their trial by video, if I'm understanding correctly. I know there are limitations to that, but the fact remains that there are some potential serious criminal trials, including by summary conviction, that could be dealt with under this scenario. And I'm wondering if you have concerns. I know that this applies not to jury trials, but to judge-alone trials. However, do you have concerns about the ability of judges in certain circumstances to be able to properly assess credibility of an accused where they're appearing only by video and not in person?
Thank you for the question, Senator. It's an important question. We are relying on, I think, the judgment and good sense of judges. If they can't assess credibility, if they can't conduct a fair trial using any one of these technological supports, then they shouldn't be doing it. And that plus the consent that an accused has to give, and accused counsel, obviously, those are safeguards that are built into this whole act, and they should work, I think, quite effectively to make sure that that a scenario where a judge can't assess credibility, for example, because of distance, would never happen. That trial would simply have to happen in person. It's not in the interest of individual judges. It's not in the interest of accused. It's not in the interest of victims for those kinds of trials to take place if the system is in any way unable to meet those concerns. And those are baked into the system. So I'm pretty confident that they will be fine. The other thing I would add is that a number of these, I've already mentioned the kind of support that exists across the system here, both with respect to stakeholders, counsel, judges, provincial administrators, as well as my provincial counterparts and territorial counterparts. But I would also just reinforce that by saying a number of these measures have been tried in part by a number of different provincial courts, and it seems to be working.
Does the Crown prosecutor also have to consent to a trial by video where there could be credibility issues? I can't actually fathom a situation where a judge thinks it's with potentially unstable internet and all of that sort of thing. And can there be a change made? I guess I'm asking two questions. Number one, about the Crown prosecutors, whether they have to consent as well. And also, is it something that has to be determined before the trial starts to take place, or can the judge determine at some point during the trial that no, this is not working, the accused is going to have to come in person?
It's my understanding that the Crown prosecutor would have to consent, and as for a change during, I suspect that consent is the answer there as well. If there's an initial plan that is then changed, would require consent of the parties. But
I'd
I'll
like
ask
a little
Carol.
more than I suspect. I want to know.
Yeah.
So yes, consent of both parties to proceed remotely, and the discretion of the court to agree that it's appropriate to proceed remotely in the circumstances of that case. And they can proceed, but if during the proceeding, my understanding is that if circumstances changed, that the court would still have the discretion to reassess. Is that correct?
Yes, in clause 46 of the bill, there's at the very beginning in section 715.222, there's a cessation provision. It's already in the remote proceeding provisions now, but this just moves it up front so that it applies globally in the part on remote proceedings. And there is a cessation provision that says that if the court does agree to remote proceedings to a person's appearance or participation by audio or video conference under this part, that they can at any time cease the use of those technological means and take any measure that they consider appropriate in the circumstances to continue the proceedings in another fashion.
Okay. And with respect to jury selection, being as you've changed those proceedings in your previous bill, would that also be something that's always done by video now, or just could be? Because again, the judge then is the one who has a role in determining whether, and there can be situations where the judge would have a definite benefit of assessing that person in person rather than by video.
Yeah, the answer is could be. It is a tool available to a judge. It is a completion of Bill C-75, as you rightly point out. Could be. And it is there to address the very real challenges that came during COVID of impaneling juries, and in particular in a safe fashion. So not bringing whole groups of people in for jury selection and therefore exposing them to the virus, for example, allowing them to do teleconferencing so that people could stay home. So it is.
Although we're now past 2 years past COVID, so
well,
we're having people getting together at major concerts.
It's evolving. That's true.
Sénateur